Section 117 states that a subject of the Queen resident in any state shall not be subject in any other state to any disability or discrimination which would not be equally applicable to him if he were a subject of the Queen resident in such other state. What does that mean? Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will discuss the meaning of Section 117 of the Australian Constitution. Is this another express right? Section 117 is usually referred to as a freedom from discrimination on the basis of interstate residence. It basically says that one state cannot discriminate against one person just because that person lives in another state. It looks like an individual right, doesn't it? But again, it has been called a freedom from being discriminated against. Quick and Guerin said that Section 117 was originally formulated in terms of an attempt to establish a status capable of being designated federal citizenship. Justice McHugh in Street and Queensland Bar Association from 1989 said that the object of Section 117 was to make federation fully effective by ensuring that subjects of the Queen, who were residents of Australia and in comparable circumstances, received equality of treatment within the boundaries of any state. Indeed, this provision was created more to foster a sense of national unity rather than to grant an individual right. It aimed at guaranteeing that there was only one people in Australia, under one sovereign, and that this character was not going to be lost either if one subject of the Queen moved within Australia or sojourned in another state. Chief Justice Mason, in the same Street case from 1989, said that this provision should be seen as a counterpart of Section 92, both sections aimed at enhancing this sense of a national identity. You know that we've talked about Section 92 already, because I know that you are subscribed to our channel. But just in case you aren't, now is the time to do it, and you can check all of our videos by clicking on the top right corner. But although this section is not as famous as Section 92, its counterpart, it's still significant today. One relevant aspect of this section is that it targets Australian citizens and British subjects. Section 117 excludes aliens and migrants from its operation. Do you want to know a dream of mine? One day I hope this section applies to me. Another important aspect is that this provision is clearly directed to the states. Do you see that? It is highly unlikely that the Commonwealth would discriminate against someone based on their state of origin. It's much easier for one state to discriminate against the residents of another state. So all in all, Section 117 binds the states. According to previous decisions of the High Court of Australia, it is relevant that this section mentions residence. Resident is a statement of fact of where the person actually lives. In 1922, Justice Isaac said that every Australian is, when all the facts are known, residentially identifiable preeminently with some one state. Indicia of residence, for example, includes the place of permanent home or the place of employment, for example. The key constitutional case about this provision is Street and Queensland Bar Association from 1989. In this case, Chief Justice Mason reasoned that the substance and the effect of the law must be considered to check whether a law will be discriminatory in the sense of Section 117 of the Australian Constitution. The case related to the requirements of a person to become a barrister in Queensland. The law initially demanded that everyone who wanted to practice law in Queensland should cease to practice law anywhere else in Australia. Before the High Court even had the chance to hear the application for special leave in this case, the law changed. The law now required that those intending to practice law in Queensland on the basis of practicing in another state should make Queensland the principal location of their practice. This ultimately influenced on the admission to practice being conditional or permanent. In that case, the High Court of Australia decided that the requirement infringed on Section 117 of the Australian Constitution. Chief Justice Mason said that if a law imposes a certain discriminatory burden on a person, but that burden would be mitigated or removed if that person lived in the legislating state, then that was a law that discriminated against persons who lived and resided in another state. As he put it, Section 117 renders a disability or discrimination invalid if the notional fact of residence within the legislating state would effectively remove the disability or discrimination or substantially deprive it of its onerous nature. As Justice McHugh said, if a law operates so that an interstate resident would be worse off by reason of his residence than he would be if he were a resident in the state in question, Section 117 will prevent the law operating to his detriment. But the High Court decided that the law itself was not going to be invalid. The provision works as an immunity on the individual from the application of the law. That is, the law that violates Section 117 remains valid. It has full effect. It just doesn't reach the person that resides in another state. And the application of Section 117 is also full of exceptions. Section 117 does not apply to elections and to the qualification of voters. Also, if there is a rational and proportionate connection between the requirements and the objective other than the discrimination based on residence, then that law will be valid. So, in Gorrell and Greyhound of Australia, Justices Dawson and Toohey analysed the decision in Street. They said all members of the court were on the view that not every kind of differential treatment by a state of a resident of another state amounts to the imposition of a disability or to discrimination within the meaning of Section 117. They concluded that guidance is then to be found in the object of Section 117, which is to foster the concept of Australian nationhood, recognizing at the same time the capacity of the states to govern their own communities, which is an essential feature of the Federation. I hope you can see that this is an immunity, even if it is a weak one that does not quite rise to the standard of an individual right. Section 117 is just another express right in the Australian Constitution. I hope you liked this video and I hope to see you again soon. Until then, ciao.